You're listening to the Valley Current.
Hey, Mike, were your ears ringing? We were talking about you just a few minutes ago. It was all good. I mean, John, he was vacillating about whether it was great or good or medium or mediocre, but that's all past history. I said to him, you're a brilliant scholar and a great lawyer, and you motivated the correct outcome in terms of the degree of vigorous advocacy that was properly given to make him a multi-millionaire on the way to becoming a billionaire.
Well, I'm glad he feels that way.
So, Mike.
I usually am not so vigorous.
So congratulations on your son leaving for Yale. I got the card finally. It arrived.
It took a while, huh? Philadelphia mail can be slow.
I would have probably come up to see him off. I guess he's on his way to Yale now, or is he working somewhere this summer?
No, he leaves on August 18th, so he's just hanging out this summer. He's playing baseball.
So are you driving him up with the U-Haul van and setting him up in his dorm in the whole 9 yards?
Everything he owns fits in the back of my SUV.
Really?
We did this one. Yeah, he did governor's school for 6 weeks last year, and we drove him to Pittsburgh, which ironically was farther away than Yale. We managed to get everything we needed to bring for him into the back of the car.
So if I remember, he was heavily involved in robotics, wasn't he, in high school, or is that somebody else?
Yeah, he was. Well, both my kids are.
Both your kids are, right?
Yeah.
And you have one that's like 4 years younger, don't you? 2 years younger?
Yeah.
So in high school now?
Yeah, he's a sophomore.
Getting ready to take the big exam that gets him into the right college?
Yeah, he's studying for it. He's studying for it right now.
Wow. So soon you'll be empty nesters. That's going to change everything, Mike.
I know. 2 more years.
You looking forward to it, or do you dread it?
Yeah, a little bit of both. I coach the robotics team. So whereas most parents, they're used to their kids, driving away and being gone. I've actually spent a lot of time with mine.
Right. And you'll probably spend more time. You'll probably get guest invited at Yale. I hope it happens. So I wanted to spend 5 minutes with you talking about what's going on with the USPTO and AI and all the initiatives that seem to be happening. You're an expert on this Alice stuff and whether patents will or won't or might or should be protective of software. What's your sense of where this stuff is going? Because certainly there's a lot of AI-based inventions that are being filed. Maybe they're just wallpaper. Maybe they're going to be defensible. Maybe we're going to see a lot of litigation. What do you see?
Well, I think you have to separate an invention from an invention of AI, if you will, right? So AI can invent anything, including things that are not abstract, the types of things that Alice would knock out. An AI that invents a new car, or an AI that invents a better mousetrap, or whatever, the types of things that are undeniably patentable. Or you can have people, or I guess AI, invent new AI, try and patent the AI.
Right.
Now, patenting the AI, I think, runs into Alice problems, and that's not even controversial anymore. I mean, there are issues I take with some of it. There's a developing case law in what it means to be abstract or not, and whether you're improving the computer. My gut says most AI inventions probably are not patentable unless they're very specific about what they're doing. But then the ABA guidance this week was about what happens when AI invents something. When can you get a patent? It all stems from somebody trying to file a patent where AI was the inventor, which seems bizarre in itself, because if AI is the inventor, then who's the agent? Did the AI hire the agent? Why should this one person get to be the one who files for the patent where the AI is the inventor?
Well, but remember,
to me, there's like a standing issue.
Right, but remember, the way AI is going to produce the invention and take ChatGPT 4.0 as the example, the latest version, you load a bunch of files. Literally, you load a bunch of files into the ChatGPT window. It has a button now that allows you to load a file.
Yeah.
Right? Let's say you load, let me give you an example, because I think this is real life. Let's say you load 5 different versions of a particular form of laptop computer and the specifications for it, basically clamshell and open sidewards and the yoga version that kind of opens externally. There's so many different versions of it, right? You load 5 different ones and you write a very detailed prompt that says, I want the next version, I want a design for a version that has these features and functions, and that specification is written by you. And you ask it to produce basically a novel, different from the 5 versions that are loaded in. And to some degree, you say your best view of what's non-obvious. You actually say that to the AI. I haven't done this test, but let's say what comes out of it is a very unique design that you would not have imagined yourself, but because you instigated the machine, it came up with something somehow, just in the way it looked at all the available comparative versions as against this. And some patent lawyer looked at it and said, because patent lawyers generally give their advice for free and they might be co-inventors, but they just literally give that away as part of their fiduciary duty. At least that's been my experience. They don't claim to be co-inventors when the client comes to them with a draft of garbage and they turn it into something good. I had a client last night that literally had a bunch of garbage and I gave her some ideas that could be turned into something really good. Okay? Let's say then that is filed. Is that something that's blocked because it, to some degree, was co-created with a computer system, which of course, we have all sorts of tools that help amplify the way we look at things, right?
Well, the PTO guidance says that as long as there's human
instigation
intervention. So in your hypothetical, I would think it's an easy case. Even outside what the ABA says, I mean, the PTO says, you've got somebody who's like setting up specs and is saying, here's what I want. People have used tools to help them invent for a long, long time. I remember back in the 90s, we used to do interviews of people and they'd sit in front of their design things and the design software would help them to build transistors in a pattern.
Right.
AI, yeah, well, a little, right? It was an algorithm, but it wasn't the engineer doing it. But if the algorithm wound up figuring out a way to put it in packed than say other transistors that led to a patent. DNA is another good example. A lot of finding DNA was brute force, right? I mean, the reason DNA, aside from it, the myriad case, DNA patents started going nowhere because it got easier and easier to decode the genetic sequence because you could brute force it with computers by testing all the sequences. And so that's how a lot of DNA sequences were found, was just trial and error using a tool. So to say, well, you can't because you did that, I mean, you could say that, but it would change the way a lot of invention and patenting has been done for as long as computers have been around.
Right. I mean, it's interesting parallel because the Design Automation Conference, which is the big annual conference, is actually playing right now in San Francisco at the Moscone Center. And we have clients that are there. I get all the invitations all the time. And I just say, design automation has been an amazing leap in progress for the United States, in particular in Silicon Valley specifically, has produced so many companies that have done so well in providing tools to engineers that are creating new chips that then create companies like NVIDIA that become a ginormous force. And it is to some degree the automation tools that enable the development of the processors that in turn enable the AI to actually produce in real time. Because if you look at what AI can do these days, you put a 50-page document into ChatGPT 4.0 or any of number of similar competitors, Gemini and others, it'll do a summary in like 30 seconds. Like you could put all your articles, like you should imagine doing this, Mike. This would be an interesting test. Take all of your law review articles, whatever it is, 500 different papers that you've done, including the unpublished ones, put it into ChatGPT and say, synthesize the themes of Professor Michael Risch over the last 20 years. It would be an interesting test to see what it does. Maybe you say, up to 25 numbered paragraphs, no more than 5,000 words, or you might want to limit it in some way because it might go on forever. I think you might be amazed at whether it instigates a new idea for a new article as a result of that kind of co-creator who's looking at your stuff and saying, well, Mike, you started off doing patents and then or trade secrets, and then you moved to patents, and then you moved to trademarks, then you did this book chapter, then you did that book chapter, then you taught this course. I think you would be amazed at the self-reflection. And I think it's going to create a new way of thinking about scholarship. I don't know if that's going on right now in academia, but I bet it's going to happen. I bet you're going to spend more time with AI than you are going to spend with any of the co-authors that you have.
Well, I don't know about that, but I will say the question is whether that's a different issue from invention as well, right? Because now we're talking about expression.
Right.
So does it give you the idea for a new article? Sure. Does it write the new article from that prompt? Unlikely. You'd have to ask it. You would have to say, you would have to give it a different prompt, right? You'd have to say, read all this and write a new article. And frankly, I don't know if a large language model would actually. I mean, don't get me wrong, it would write something new, but whether it would make sense, whole other story, because it would have to figure out what words go with what words, and a lot of it would probably be nonsense. But then the question is whether or not creation of expression is different from an invention, because an invention is an idea of one thing, whereas is really all of it, all the expression, not just the idea. That's why we have the idea expression dichotomy. Right? If you could protect just the idea for the article, that'd be one thing. But the question is whether you have the entire article created as a whole other thing. And I think invention is the same way. You can come up with new ideas for inventions, and those are much more easily protectable because you're not asking it to create a whole new thing.
You could say that comparison just gave leads to, if it gave you a new trademark, a new word, a new summary, if you said, summarize in a very catchy phrase what Professor Mike Risch is all about, and it came up with a really beautiful, catchy phrase that you trademarked, the trademark law wouldn't care that you generated that phrase as a result of an AI. They wouldn't ask that. They would say, the fact that you put it on your product or service and you're selling it in commerce is what matters. The fact that it was cut
where you got the idea.
Right. That's the interesting part about trademarks. It doesn't care about where it came from. It cares more about how you put the label on. I mean, obviously there are cases where thefts happen, but if you're using AI to generate a good name for a trademark, I don't see any prohibition at all around the fact that you're using AI to do it. That's called brainstorm, right?
Well, the basis for protection of trademark is a completely different constitutional provision. So,
right. The commerce clause.
So there you have it.
Right.
I mean, you might still have derision, right? If you came up with AI or you stole it from somebody or whatever, but the protection itself, and it's an interesting issue. Like, for example, I have a colleague, Brian Fry, who writes a lot about plagiarism, and his theory is that plagiarism is not a thing. In fact, he wrote a recent thing where he's like, I offer, anybody to take 10 of my articles and claim them as their own. It's like a right of publicity thing. Take my article, put it on your name on it, put your name on it, republish it, etc. And the part that gets missed, I think, in his argument is, okay, maybe from a copyright creativity point of view, plagiarism shouldn't be a thing. But from the whole like theft of idea, that's an issue, right? It's not that I care, even if he doesn't care whether I put my name on his article, I care whether people think I wrote an article or not.
Well, I don't understand. His view is basically everything's in the public domain. And if someone wants to say they're Jack Russo or Mike Rich, well, we want to inspire people to do their own work. The interesting part is ChatGPT is leveraging off of a corpus, some of which is copyrightable or copyrighted or copyright registered even, some of which might even be trade secret or believed to have been trade secret, and somehow it was inadvertently disclosed. I'm sure we're going to see some of these cases.
Yeah, I don't worry about the trade secret so much, but yeah. Well,
you got to imagine that these cases, I mean, I imagine a world that we're going to see a tsunami of cases when people really actively start using in a regular course of business, a 40-hour work week where it's like day in, day out. It's not that way right now.
I guess the trade secret claim will wind up being people who don't understand that when you use ChatGPT without the special license, that they're incorporating what you upload to the corpus.
Right. They're inadvertently disclosing company secrets, which is why some companies are banning the use of ChatGPT. But now in the latest version, when you upload stuff, they actually ask you, are you willing to make this public? And you can just say no. So they give you kind of a local sandbox, and that will open up corporate usage in a big way, if you ask me.
Microsoft's already ahead of the game on that because Copilot, you can get a corporate license where they keep all the upload secret.
Yeah. So to me, the interesting part is as companies start to use ChatGPT, the institutional knowledge stays in the institution even as people leave. So you can probe the corpus and get information, even though Chuck or Harry or someone else was let go and is not available anymore. That's a big benefit for corporations because they lose a lot as people with institutional knowledge walk out the door. But where I wanted to focus on is the ABA seems to be more in favor of just let the patents issue and let the courts kind of decide whether the patents should be struck down. Effectively, what has been the case with computer software. There's a lot of patents that get filed and issued as valid or presumed valid software patents, and then the courts get to kind of knock them down regardless of what the presumption is, right?
Yeah, it's a very pro-patentee point of view. I think part of it is they recognize, saying earlier, that we've always used software as a tool, and we've never asked how much human interaction there was. In fact, we allow accidental inventions like the Post-it note. So if we allow that kind of invention, why can't we have an accidental AI invention? And so I think his position is that by requiring using it as a tool, giving it a prompt, if you will, then basically all you're doing is reversing decades worth of precedent of patents given where we didn't require such human participation with accidental or automated invention.
Right. But let's look at photographs. Photographs are very simple snap of a camera these days. Obviously, there can be more than that for a professional photographer, but it's not sweat of the brow kind of creativity. It really is pretty fast. And often it's just a lot of different automated machine gun-like shots, and then they pick the best one that happened to happen because someone moved in a certain way, right?
I have colleagues who believe those kinds of simple snapshots should not be protected.
Right, but the law has gone in the other way, just generally speaking.
I think that's right. So that's sort of the ABA point, right? Although that's copyright, again, not patent, but the basic gist is exactly that. The fact that they chose the tool to use, the fact that they chose the inputs to use. In fact, even with an AI invention, the fact that you fed it the inputs on which it learned of the different laptops using your example.
Right.
is a choice to the invention.
Right.
And so to say that you didn't have any like interaction with it to call it a patent. Now, the bigger question is whether the AI company should have some rights in addition to the human who put the prompt in.
Yeah, I mean, that would make all hell break out loose, because that's like saying the AI company also gets a license as a co-creator, and they can decide to say, everyone should have access to it, which means the whole royalty nature of why you're getting the patent to begin with falls apart, right?
A company tried this on the copyright area. They sued Disney saying you didn't have a license, or your sub didn't have a license to this special effects software, and therefore now we own all the special effects that came from that software.
When was that? I didn't see that one. That was
in the last couple of years.
Really? Interesting.
Yeah.
If we were to predict what the Supreme Court in its current sort of formulation, those 9 justices, would do with an AI case once they get it, and they will get one for sure, what they will do in deciding whether to go broad or narrow, because they've avoided Alice in a painful number of attempts that have been made. What is it, like 12 different attempts that have been made that have all been rejected? At least 12, right? And they don't seem to want to touch it. And they seem to accept that the Federal Circuit is split, as best I can tell. It seems like the Federal Circuit is split.
It's actually not. I mean, Jason Rantanen at Iowa did a study. It's actually not that split. It turns out that most of the time you can tell, most of the time they agree. There are a few dissents, but it's really not nearly as unpredictable. Now, the outcomes may not be the outcomes you want. Most of the time, most people can predict whether something's going to be upheld.
So you're saying there's actually a rigorous way to do the 2-step test. And Jason, what's his last name?
Rantanen. He posted about it on Patent Leo. He's one of the co bloggers at Patent Leo.
Of which site?
Patent Leo.
PATENTYO.
Yep.
And you're saying that he says most of the time there's a clear majority that is consistently doing the 2-step test correctly.
It's a pretty persuasive article, I have to say.
Really? Can you get me the site or find the site and send it to me? Because I'm interested in this, because I get these new clients that come in all the time. We get them, and they're like, "What do you think?" And I say, "Look, most people, if they have the budget, will file. They'll get the patent. They'll hang on to it. And they'll wait to see what the manifestation of the Supreme Court is, and whether it's likely to go in a direction, and whether the Federal Circuit starts to harmonize." And you're saying the harmonization's already occurred.
It's happened.
It's happened. And maybe the Supreme Court just adopts that harmonization eventually versus rejects it, because you could say they usually reject a lot of stuff that they take from the Federal Circuit, right? When they do take cases.
Yeah. If they haven't, says that they're good with it.
Right. It seems like that's the meta message. The meta message is they want the specialization of the Federal Circuit to continue. They don't really want to butt in. And when they butt in, they probably sense that they're going to get it wrong, because truthfully, even in this little call, you've been very finely distinguishing patents from trade secrets, from copyrights, from trademarks correctly. But I have to tell you, I don't think the Supreme Court justices do that. I think they think of it as intangible intellectual property as a whole, and it involves some form of monopolization generally. And it's just a question of whether it's needed monopolization. That's kind of the way they look at it from 30,000 feet in the air. They're not distinguishing different types of snow. They're just saying it's snow, it's wet, and it's a cold. And that's it. That's the way I see what they do. It's more like a butcher than a surgeon.
Well, I think that's probably true.
Right?
As for your question, my gut says the Supreme Court says if the Davis case, the one where the inventor goes up, the Supreme Court says, no, the inventor must be human. If the question goes up of whether a person can get a patent using AI, I think the Supreme Court backs the PTO. It depends on whether the human had some input, and they basically rely on that conception.
Okay. So you're saying that the cases that we've seen that say, hey, a gorilla can't take a picture and get a copyright because the gorilla is not a human being will play out even in these cases dealing with AI on the view that AI is the principal inventor, then fundamentally it's much more like a gorilla, non-human. So therefore Congress has to change the statute. We're not going to rewrite the statute that Congress created that generates from a human. And that's really the test. Well, thanks, Mike. Good luck with the summer. And at some point, we'll do another debriefing because the closing will happen and John will get his payday. And hopefully we'll get a full debrief because John didn't give that to us. And I hope you're on that Zoom. It probably will happen in July. I'll let you know. Great. Thanks very much. Have a good time. Bye-bye.
Thank you. Bye-bye.
Tune in next time on the Valley Current.